Good morning and welcome. Thank you so much for joining us here this morning on our new Capital Group YouTube channel. I'm Kevin FitzPatrick, a partner at the Capital Group and CEO of the Government Technology Insurance Company. We provide healthcare, commercial insurance, and 401k strategies to the Washington, D.C. business community. We're going to spend about an hour together today discussing key legal issues regarding reopening in a COVID-19 environment. To a certain degree, we are all in uncharted territory here. We know there's a lot of uncertainty on how to safely bring employees back to the office and back to the work site. Our legal and compliance teams have spent the last 2 weeks working to develop best practices as it pertains to reopening for what we all hope is the backside of COVID-19. We've assembled the latest data from the CDC, EEOC, OSHA, and the employment law community. We're going to share with you today what we've learned. We understand this is a fluid situation, and about an hour after this program is finished, additional information will have inevitably bubbled to the surface. Our legal and compliance departments are ready to help you with your questions, provide guidance, strategic advice all throughout the pandemic. Please don't hesitate to reach out. With that, I'd like to welcome our panel of experts today. We have Beardall, in-house general counsel at the Capital Group and COO of the Government Technology Insurance Company. Andrew's a graduate of the Columbus Law School at Catholic University and holds a graduate degree in neuroscience. We also have with us Marjory Robertson, Vice President and Senior Legal Counsel from Sun Life, and a graduate of Boston College of Law. We encourage everyone to put your questions throughout the program. We're going to try to get to as many of them as possible. If we don't get to your question, please feel free to contact us post-program, and I promise we'll do our very best to answer it. Our contact information will be posted at the end of the program and being recorded for future reference. So we have a lot of information to share today, and without further delay, I'd like to turn it over to Andrew Beardall. Andrew, take it away.
Good morning, everyone. Thank you for joining us. As Kevin indicated, we're going to be talking about a lot of various factors that go into reopening and allow your employees back into your environment. But the first thing I'm going to review is something that you've probably all heard about before, but it's as important now as it was 6 to 7 weeks ago when we heard about it first. And that is the sick leave and extended family leave provisions of the FFCRA, the Families First Coronavirus Response Act. Now, this was one of the first big packages. Actually, it was the second coronavirus-related package. It was passed by the U.S. Congress, and it had two major components in there that got a lot of press, but that sort of died off. However, both of these components are in force until the end of the year. And you have to be mindful because this condition is not going to go away, even if it's lessened considerably. First one I'm going to talk about is the expanded family and medical leave. Go to the next slide, please. FMLA, as we all know, is a provision that allows people time off if they are ill, if they have to take care of someone else who's ill, but expanded FMLA has a couple important differences. First, it adds a new event into it. The first time they've done something like this, and that is if your youngster has no daycare or no school, that is now a triggering event for FMLA. And this FMLA, unlike the classic form of FMLA, is paid. It's not paid at your regular salary, it's paid at 2/3 of an employee's regular salary, up to a maximum of $200 per day. And this applies to all companies with fewer than 500 people that had the employees work for at least 30 days. So as you can see, this is something that might crop up down the line for individuals, especially come September when school starts back up or perhaps doesn't start back up. Now, the first 10 days of this leave are not paid, but the remaining 10 weeks of it are. The good news is this is something that's going to be revenue neutral. Flip to the next slide, please. As you calculate out that pay, if you could flip to the next slide, please, Rob. as you calculate out the pay, it is $200, up to $200 per day, or 2/3 of their actual salary. It can then be applied against as a tax credit against the employer's deposits for the Social Security taxes when they pay payroll. So, for example, if you have somebody who takes the maximum $10,000 here, which would be 10 weeks, $200 a day times 5 days a week, $10,000, they would be able to take a $10,000 credit against the Social Security tax payments that are made. If your payment isn't $10,000, don't worry, it'll just continue rolling until it is took off. Now, it's important to know that anything that's paid off in this manner cannot be forgiven as part of a PPP loan. So that's the extended FMLA. Let's go on to the next one, if you would. The other component I want to talk about is the new sick leave provision, the emergency paid sick leave component of the FFCRA. Next slide, please. Now, if an individual is unable to work because they have this condition, or because they have been quarantined, and quarantine doesn't mean a stay-at-home order from the governor. It means an isolation order. It means you're not allowed to get off that cruise ship. It means you are confined to that hospital. You would be eligible for this. It also applies if you have to take care of a family member who may have the coronavirus. Any full-time employee is now allowed to take 80 hours of paid sick leave for these reasons. And it's on top of any you might otherwise have from your company. Yeah. The good news on this, if you go to the next slide, please. This is also revenue neutral. Right? The employee will be paid their regular rate of pay up to a maximum of $511 per day. Why 511? No one really knows, but $511 a day. And if you yourself, if the employee himself is sick or has been isolated, if you're taking care of a family member, it reverts to that other formula of 2/3 of your salary or up to $200 a day. And much like the extended FMLA payments, these can also be taken as a credit against the Social Security deposits and will not count for PPP loan forgiveness. It's important to note also, this won't count against you for PPP loan forgiveness if you're showing a lowering of payroll because of that. But that's just a quick blurb on these two things because they could still pop up. And what I'm going to do now is hand off the baton to Marjory Robertson and let her talk about some of the logistics and legal aspects of bringing people back into the office. Thank you very much. Marjory?
About a topic that I have been reasonably obsessed with, which is how to reopen safely. And if we could move to a slide, and I don't see a slide. Okay, there we go. So just a word of caution that I've been asked to give. I can't give legal advice. Another interesting thing about this particular webinar is that I also can't give safety advice. And so to the extent that I'm talking about what a state or local order suggests that you do in order to reopen, I encourage you to consult your own safety expert. I am not a scientist, so I can't guarantee that any of these measures work, but it certainly seems to be what a lot of experts are recommending. So we can move to the next slide. It's a jam-packed agenda, but we are going to hit the high points of many of these things. I first want to talk about sort of some common legal themes that will be emerging as we reopen. Then I'm going to go through some of the common details in many of the federal, state, and local orders and guidances. And then at the end, we'll talk about, how do you deal with disabilities that are going to come up in the workplace and employee fears and employees complaining. Next slide. We can go on to the next slide. This is just a divider tab that you have for when you get the materials. We're going to review key legal issues. So OSHA is a really hot topic. I have to say that in my career, I've always worked in an office environment, and so I didn't actually know that much about OSHA, but I have been learning an awful lot about it. It imposes a general duty of care that requires employers to provide a safe and healthy working environment. It is a very hot topic in the context of reopening for COVID-19. OSHA can have both specific requirements and then this general requirement, and it can include obligations to clean and sanitize, to screen employees and visitors, to enforce social distancing, to provide appropriate personal protective equipment, and then to respond appropriately if somebody displays COVID-19 symptoms at work. Next slide. Sorry, there we go. So a second overarching legal issue is the Americans with Disabilities Act. And it has a number of requirements and prohibitions that are relevant to you as you consider reopening. Ordinarily, under the ADA, you have very limited ability to make medical inquiries or to require medical exams. But when there is a pandemic, the EEOC has issued a special guidance that, I like to say, relaxes somewhat the requirements of the ADA. And so you are expressly permitted to follow guidance from the CDC and other reputable medical sources. You don't get complete free range. You need to focus on exposure and symptoms related to COVID-19. You have to be careful not to be asking about other questions, including underlying medical conditions. If you obtain medical information, you have to keep it confidential. And then you may have obligations to accommodate employees, both those with COVID-19 and those who do have underlying conditions that could be disabilities if they disclose those conditions to you and ask for an accommodation. Also, in this new work arrangement, I actually am now working remotely, as are probably all of you, and it has created for our workforce a lot of new requests for accommodations because people's home offices may not be set up ergonomically correct. So you can have an obligation to accommodate employees both on-site and those who are working remotely. Next slide. Workers' compensation. There's been a lot of writing among lawyers about what type of legal issues are going to arise, and workers' comp is a hot topic. In fact, there's been talk in Washington of adopting an immunity for employers so that they won't be subject to workers' comp. Workers' comp, again, because I'm in an office environment, we don't tend to have a lot of dangerous situations, but I have learned that it covers benefits for occupational diseases. So the type I think of most commonly is mesothelioma, which is an illness that employees got when they worked with asbestos. But workers' comp doesn't typically cover the ordinary diseases of life to which the general public is equally exposed. But if an employee can show a direct causal connection to the workplace, then they may be entitled to workers' compensation coverage. It is one of the reasons of many that it's so important to have appropriate preventative steps in the workplace so that you can help limit your potential exposure for a workers' comp claim. Next slide. And then I spend most of my weekends trying to update the information I have on the incredible number of federal, state, and local COVID-19 related orders that impact employers. As we're starting to reopen, you're seeing lots of activity because the federal government has explicitly said they think a lot of this should be left to the states and localities. You are really getting a patchwork of different requirements. It is essential if you have operations in different locations that you become aware of what the current guidance is that is coming at not only the state, but also the local, and that can include cities and counties. And you need to find out, are you allowed to reopen? And if so, what are the rules? Next slide. So this material, this is bonus material that you will get. It is available on our website. We can also distribute you the slides. They're a complete slide deck, hundreds of pages. I will be updating it this weekend because there have been some new orders issued, including in my state, Massachusetts. What I try to do is go through and summarize the key guidance that's to give you practical tips that's relevant for the different areas. So we won't go through that in boring detail here, but you will have that available to you. Next slide. So the next section of this, I'm going to summarize things that have shown up in a lot of these federal, state, and local orders and guidance. And so one big topic that's addressed is temperature checks. We can go to the next slide. The EEOC pandemic guidance permits you as an employer to take the temperatures of employees and other individuals visiting your premises. Ordinarily, that would be considered a medical examination and you may not be allowed to do it. But essentially, the pandemic guidance means that COVID-19 is so serious that it creates a direct threat to the safety of employees. And so that is why you are allowed to do it. It is advisable, according to CDC, that you communicate this process in writing. You don't want surprises. Also, be aware of local requirements. California law, their new privacy law, has been interpreted to require a detailed advance written notice. The CDC recommends that you establish a threshold temperature over which an employee or another person will not be admitted entrance. The CDC guideline is 100.4 degrees Fahrenheit. I really want to emphasize, we've been talking about this at Sun Life. I think you really need to draw a firm line in the sand and not make exceptions that some people can come in if they're over the threshold, but some people can't. I think that creates more problems. It is recommended to do testing in the least invasive way possible. If you can get your hands on reliable touchless devices, I think those are best. If you decide you're going to keep the results, a lot of employers, including Sun Life, we're discussing, do we want to keep the results? For how long? There's some thought that maybe we keep them for a week or two so we can look at trends. Whatever you decide to do, just know that you have to keep those results confidential and store them securely, separate from any personnel records. Next slide. So this is a slide that I actually have given a lot of thought to, and it's not written about that much, but I think as a practical matter, it's one of the things you should be thinking about the most. If you're going to be doing temperature taking or other screening, think about how you're actually going to do it at your location. You need to, for one thing, plan for social distancing. If there are going to be lines forming in order to get in, you probably want to think about putting down the tape at 6-foot measures to keep people separate. Also, think about where you're actually going to be taking the temperatures. I recommend that it's in a private location so that the results are confidential and also they can be discussed discreetly with the employee. I also think you need to give some thought to how you're going to exit people from the building if they have a temperature. You don't want them walking by others and exposing them. You want to try to avoid embarrassing them. Another issue that has come up, has been talked about, is if you have non-exempt overtime eligible employees, do you need to count the time they're waiting in line as work time? Under the federal FLSA, the big issue is, well, is it a principal working activity? I think the federal courts have been more interpreting the law in favor of employers, but in a lot of states, this has come up, including California. And the closest example that I could find are employees who have had to wait in line for security checks. And a number of state courts have concluded that that is protected working time. So it also may also make employees more willing to comply and be cooperative if they know they're getting paid. Next slide. You can also rely on self-administered temperature checks. So you can ask your employees and others to self-administer a temperature check on a daily basis before they come to the work site, and then to verify the results in writing before they enter the work site. This is definitely a less costly way, but it may be less reliable. I actually think that even if you're going to take the temperatures at the work site, I would consider requiring employees and others to take their temperature at home before they leave. For one thing, it will help reduce exposure if the person has a temperature. For another, it may help eliminate surprises at the workplace when somebody comes and has to be turned away. Be very careful if you start challenging whether somebody's telling you the truth or not. Just be mindful that whenever you start treating people differently, you could be opening yourself up to a discrimination claim. Next slide. So the next section is going to talk about other screening measures that the guidance, CDC, and other state and local guidance have addressed. Next slide. Under the EEOC, with the pandemic guidance, you are actually allowed to ask questions about employees and others coming on site, including symptoms, what symptoms they've had for COVID-19. Bear in mind the symptoms are evolving, and so you should stay up to date at the CDC. And originally it was just breathing issues, and now it's expanded into a variety of other symptoms. You can ask about diagnosis, you can ask about exposure. Whatever information you are told, you have to keep confidential. And if you're going to put it in any kind of a written form, you have to store it separately from other personnel information. Next slide. So what questions are not okay? There is a lot of medical evidence and talk that certain people are in more vulnerable positions. So individuals who are older, and I've seen the dividing line be age 60 or age 65, individuals who have underlying health conditions, individuals who are pregnant. Those are all vulnerable populations, but you should not be asking people or screening people based on whether they are in those conditions. You could be accused of age discrimination, disability discrimination, pregnancy discrimination. If those individuals raise the subject and they tell you, I'm in a vulnerable condition, or my family member is, I am concerned about exposure, you definitely need to listen to them. And in fact, the EEOC has recently said you need to engage in an interactive process about an accommodation. But you yourself should not be making assumptions or allowing certain people to return based on your perception of what might be going on. Next slide. Testing. Lots of talk in the news this week in particular about testing. Hopefully we will be at a point where testing can be used as a reliable way to screen people. There are 3 different approaches to testing that are being developed. One is to see whether you currently have COVID-19. Another is to see if you previously had it and whether you have antibodies that might protect you and others. And the third is if you've been exposed, to do contact tracing to limit the exposure. There's been a lot of talk among employers about, can they require any or all of these? The EEOC has actually made clear, absolutely, you can require tests before employees enter. I think one of the problems for employers has been that the tests aren't that available, maybe not that reliable. I actually think with the contact tracing apps, you need to be very careful about obtaining information or requiring employees to tell you about their contacts outside the workplace. I think you could run into privacy issues. Good news that if a vaccine is developed, you may be able to require employees to become vaccinated as a condition of coming on the work site. You will, of course, have to evaluate accommodations for religious beliefs and disabilities. Next slide. So personal protective equipment, or PPE, as I've learned that it is referred to. Go on to the next slide. This is a OSHA requirement in certain circumstances. Again, because I'm in an office environment, I haven't had that much personal familiarity with it, but it is a hot topic that is being talked about for COVID-19. Under OSHA, there's a whole process. If a hazard exists, you need to evaluate whether PPE is needed. And if you determine that it is, you can require employees to use it. And the flip side of that is employees can require you to provide it. And the type of PPE that's relevant for COVID-19 includes face masks, gloves, goggles, face shields, respiratory protection. So the problem with PPE under OSHA is there's a whole complicated process you have to go through. You have to perform a hazard assessment. You have to consider whether alternative options can protect the employees. If you decide that PPE is necessary, you have to identify it and provide appropriate PPE. You have to train your employees in how to use it, how to care for it, how to clean it, when to replace it. And then you actually have to have a written plan that you prepare and periodically review. So it's a lot that you have to go through if PPE becomes involved. Next slide. So with regard to COVID-19, originally the CDC only recommended the use of PPE for healthcare workers who had greater exposure to patients who may have COVID-19. But over the course of the last couple of months, there has been more and more evidence emerging of how much spread of COVID-19 is happening by asymptomatic individuals. And so the CDC revised its guidance, and they now recommend that even non-healthcare personnel wear a cloth face covering. They make very clear this is not a surgical mask. Those should be reserved for the hospitals. In fact, they say that this cloth face covering can be homemade from household items. They do recommend that it be kept clean through washing. But they've made clear that the main purpose of it really isn't to protect the person wearing the mask. It's to protect others who could be subject to asymptomatic spread. Next slide. The states and the local governments, the counties, the cities, they have jumped on this bandwagon. And in the materials that I referred to that is separate, I have created a few charts that relate to various state and local orders where they are either mandating or recommending the use of face masks in certain circumstances. And I wish that I could say they were all the same, but they're all different in sort of a maddening way. Some are mandatory, some are recommendations, some apply to anyone who goes out in public outside of their house. Some only apply to employees at essential businesses. Some are limited to public-facing businesses. Some of them come right out and say the employers have to pay for the face coverings. Some also add in other requirements, like the employer has to provide disposable gloves or has to have ample supply of wipes available. Some also require mandatory breaks to wash hands. Very important if you're opening that you find out what is required and probably that you err on the side of caution. Next slide. So now we're going to go through some of the other safety measures that are recommended. Some of them are common sense. Some of them are things that I hadn't necessarily thought of. So we'll go to the next slide. There is a huge focus on maintaining and reinforcing social distancing. And in fact, I will say that a lot of these state and local orders contain language that either require you as an employer or recommend that you continue to permit remote working for as long as possible and for as many people as possible. I think that could lead to some legal claims as we move to reopening and managers start saying, oh no, you have to come into the office, and the employee is able to say, well, what do you mean? I've been working successfully for 3 months from home. So it is important to make sure you understand whether your state and local order is phrased in the form of a recommendation or a requirement. If you do start opening again, a lot of these orders have limitations on occupancy, anywhere from 25% to 50%. They also recommend that you do certain physical changes. You create one-way aisles, you install plexiglass. You've probably seen that in a lot of retail establishments. You put up tables or other physical barriers to create distance. If you have any type of business that requires delivery of any type, that you try to create contactless delivery options. High recommendation of using the tape to mark 6-foot distances. And then one thing I had not thought about is elevator usage. If you are in an office environment, particularly if you're in a city, you may have elevators and you need to think about how you're going to limit the number of people going on, maybe have face masks available, maybe do the tape, although I'm not sure how helpful the tape is as an elevator, but it is something to think about. Next slide. So some other workplace considerations, sometimes you're recommended to move desks and workstations to create distance. If you have one of these open floor plans, which we have at Sun Life, they are not the best design to have in the COVID-19 world, and you may need to start putting up partitions. You can also make only certain workstations available and close off the others. A lot of these orders recommend or require you to close common areas, including conference rooms as well as cafeterias. And in fact, some of them say you should make the employees eat lunch alone, either at their desk or in their car. They encourage you to be creative about creating touchless entries and devices. If you have a trash can with a lid, take the lid off or find a way to have it open without touching. A potentially expensive remedial device is to improve your airflow and ventilation. So you may need to think about that, or that is not something, I'm not an expert in that. That may be something you need to talk to an engineer about. And then a lot of the orders require you to improve signage to have it around to remind employees about basic ways to protect themselves. Next slide. Also a focus on changing workplace behavior. There are recommendations or requirements that you hold fewer in-person meetings, that you limit the size of gatherings, that you have clear instructions to employees. They shouldn't be using others' workspaces or equipment. A lot of these orders, particularly in what they call phase one, still want you to have limitations on non-essential travel. And then there are other measures here. Next slide. And then the cleaning measures, there are lots of cleaning measures that are being developed, and they're quite significant. I think this is an area where an employer could be exposed if they don't follow the more stringent cleaning requirements. You're supposed to have regular hand washing, lots of instructions about proper sneezing and coughing etiquette. Having ample supplies of face covering, gloves, sanitation materials, I think will go a long way to protecting employers, making sure you have frequent sanitation of high touch areas. Next slide. So we've now kind of concluded the overview of the different types of things you can do to help remediate the potential exposure. And now we're going to talk about just some of the more practical issues that are going to come up, starting with accommodations that you're going to need to at least consider making for disabilities and employee fears. Next slide. Interestingly, accommodations come up even in the context of these remedial measures. So if you're going to require employees to wear gloves, you may have to provide non-latex gloves if somebody has an allergy. Also, a number of the state and local requirements on face coverings make clear that you can't require somebody who has a medical condition to wear a cloth face covering. And one example they refer to is somebody who relies on sign language assistance. And so one of the guidance actually said you may have to provide clear face masks, not only to that person, but to everybody else who they need to communicate with. Some of these state and local orders say you cannot ask for documentation of the medical condition. I have seen some lawyers recommending that if somebody says they can't wear a face covering because of a medical condition, you should send them home. I would hesitate to do that. If the person can work from home, that's one thing, but if it means they'd have to take an absence, particularly an unpaid absence, I think that the law may require you to engage in an interactive process to come up with some other way of accommodating them. And one interesting issue is that the cloth face covering is really designed to deal with situations where you can't have social distancing. So if you have a way for this employee to properly social distance at work, they may not need to have a face mask. I also think we may start to see more and more demand for those clear plexiglass or plastic face masks, which I think are more amenable to people who have breathing issues and also for people with hearing issues. Next slide. So the EEOC in the last few days issued guidance about what accommodations you have to make for high-risk employees. So under the ADA, if an employee has a disability, you absolutely need to engage in the interactive process and provide reasonable accommodations. In addition, in some states, employers are also required to make accommodations for pregnant employees. Pregnancy itself is not a disability, but there have been more and more laws protecting pregnant employees. If the duty to engage in the interactive process is triggered, you have to grant an accommodation unless you can show that it would create an undue burden, that it would relieve an employee from performing an essential job function, or that it would create a direct threat to the safety of the employee or others. As I noted, the EEOC has indicated in its recent guidance that you should essentially treat somebody who says they have an underlying medical condition that makes them more exposed to risk as though they have an actual disability that qualifies under the ADA, and you should try to accommodate them. I note that some of the state and local orders also contain that requirement, and some go further than others. Washington State actually really puts a heavy burden on employers to try to find ways to accommodate the high-risk individuals. You're in a tough spot here because you're not allowed to make decisions because you assume somebody needs it. But if they ask for it, then you do need to accommodate it. So it can be a tricky balancing act in terms of confidentiality and not making assumptions. Next slide. So I've been getting lots of questions of an employee's just afraid to return to work. And so do you need to accommodate that? In general, a fear that isn't arriving out of, that doesn't come from some underlying medical condition, which I'm going to talk about in a minute. And if it's not based on any evidence, if you don't have outbreaks in the workplace, you're doing all the cleaning, you're doing the social distancing, you probably don't have a legal duty to accommodate that. But remember, if the employee has an underlying disability that makes them more at risk, or it's a psychological impairment that makes them more subject to bad consequences because of their fear. So if they have obsessive compulsive disorder or a severe anxiety disorder, and their doctor says that if they are required to come to work, it will cause their condition to deteriorate, you may need to accommodate that. I also just urge you to use caution. If you have employees saying they don't want to come into work because they're afraid, find out what it is, and to the extent they identify actual things in the workplace, this is your opportunity to prevent a potential OSHA claim or a workers' comp claim. So I think that you need to show empathy when employees are raising concerns and take whatever steps you can that are reasonable to try to address them. Next slide. So now we're going to talk about the many issues. This is where people are predicting there's going to be a lot of litigation dealing with employee concerns about workplace safety as we start to reopen the economy. Next slide. It is important to bear in mind there are a number of legal issues that can come up. Under OSHA, if you don't properly and promptly address and alleviate dangerous conditions, you can be held liable. You can also be held liable if you retaliate against an employee because they've raised a concern about workplace safety. There has been more and more discussion among lawyers about how we may see unions re-emerging in importance as employees who are unhappy about safety in the workplace start to organize. Also be aware that the National Labor Relations Act protects what they call concerted activity. And that's where two employees get together to talk about concerns or how to fix safety issues or other workplace issues. That is considered protected concerted activity, and employers can get into trouble if they try to shut that down or retaliate. There are also state whistleblower laws that are relevant. And then anytime you start to treat people differently, you need to be mindful that there are federal and state discrimination laws that are out there that could expose you to liability there. Next slide. One thing I learned in my review of OSHA is that there are, in certain circumstances, situations where employees have the right to refuse to do work. They have to prove all of the following conditions. They have to show where possible, they asked the employer to eliminate the danger and the employer didn't. They also have to show that they're refusing to work in good faith. So they genuinely believe there is an imminent danger. And a reasonable person would agree that there is a real danger of death or serious injury And then lastly, there just isn't enough time because it's an emergency to be able to call OSHA and ask them to do an inspection. I think those are pretty tough standards to meet in the ordinary world, but we're not in an ordinary world, and especially where there's so much that is unknown about this disease and so many people have fears about it. I think that it is possible that employers could find themselves in this situation. So I think step number one is the most important. If the employee comes to you about a danger, do try to take steps to address it. I think it will help protect you in a number of ways, including not exposing you to one of these refusal to work claims. Next slide. Workers' comp. Also, I think it's worth talking about workers' comp. Many employers are worried that workers' comp claims will come if people get exposed to COVID-19. The interesting thing about workers' comp is it's already a kind of immunity for employers. The workers' comp system was created so that employees couldn't go into court and sue you. Instead, it was an administrative system that gives them some compensation. It's supposed to be considered moderate compensation for workplace injuries in exchange for protecting you from lawsuits. Some state workers' comp laws do not give you that immunity if the employer has acted willfully or wantonly. So you do need to be mindful that in addition to workers' comp, you could be subject to penalties. In Massachusetts, you get penalties if you've engaged in willful and wanton misconduct. As I mentioned, flus are considered ordinary diseases of life, generally not covered, but they may be with COVID-19. Another thing to be very, very mindful of is that if you're a retail establishment or even an office building and you're having visitors come on site, there is no immunity there. You can be sued by customers, visitors, vendors. So bear that in mind in terms of that's another good reason to follow the safety protocols. You will only be held liable for negligence, and to the extent you can show you're complying with all of the things that the state and local governments are requiring, that should help prevent and protect you in the event you are sued. Next slide. Questions? Oh, and this is an HRCE approved session. As you can see, the activity numbers are on this slide for both SHRM and for HRCI.
Well, thank you, Marjory. That was a lot to take in 30 minutes. Really appreciate the thorough understanding you laid out there. We have a handful of questions here for both Andrew and Marjory. I'll start with the questions from Marjory. This is a question from Terry. Our company is utilizing self-testing at the front desk, requiring employees to enter their name, temperature, and time on a clipboard log. This information is accessible to anyone who walks in. Is this okay?
It's not a good idea. I would say no. I think that the information should be shared privately and kept separately. So not sure how to deal with that, but maybe letting the employer may not realize that they have limitations on who they can share the information with. So maybe a gentle reminder would help. But no, that doesn't sound like a good process.
Thank you. And this is a question from Lyndon. Does heightened vulnerability to the virus qualify as a disability for the purpose of ADA?
So it, in and of itself, without a definition around it, it probably is not an actual disability, but often the heightened vulnerability may be the result of a disability. So if somebody has a medical condition that is considered a disability that makes them more exposed, then they would be entitled to have the interactive process engaged in order to do an accommodation. The other thing the EEOC has in the last few days, and I will be updating my slides, the separate slides to summarize it, they have really put some pressure on employers to essentially treat those individuals who have a heightened vulnerability as though they are disabled, to engage in the interactive process and to try to come up with a reasonable accommodation. So I think there is a lot of pressure coming, not just from the EEOC, but a lot of these state and local orders. They also are containing language that you really should make efforts to accommodate those who are particularly vulnerable.
Thank you. Andrew, if we have someone out on paid sick leave, should we code it differently in our payroll?
All right. Well, that's a terrific question, and we get a lot. The first step is reach out to your payroll provider, because an awful lot of the big ones, Paylocity, ADP, Intuit, they've already done that work for you. And as long as you let them know that somebody is taking the FFCRA approved extended FMLA or expanded sick leave, they've already got a process in place to note that differently and help you with the application of that against Social Security taxes. It'll also show up on your end of the year tax material, though no one's quite sure what that'll look like yet. If your payroll provider does not have something like that in place, the answer is yes, it's probably a good idea to code it differently for those people, just for your own internal tracking, and it will help you down the line when you go to do your taxes at the end of the year.
Terrific. Thank you, Andrew. Andrew, I'm going to come back to you with this next question as well, too. If an employee has used 48 hours of paid sick leave intermittently, at what point would the paid expanded FMLA kick in light of the first 10 days being unpaid?
Okay, if they've used 48 hours of sick leave, I'm a little confused, because to use that sick leave, it's either because you've got it and are isolated, or you are taking care of someone else. So let's just say, for the sake of this question, it's been used intermittently because you're taking care of a third party who might have it, a youngster or a spouse. Then the first 80 hours of time you spend is unpaid. So if you're using sick leave to supplement some of that, say 48 hours of it, then the delta between the 48 hours and the 80 hours will remain unpaid until the extended FMLA payments kick in at week number 3.
Terrific. Thanks for the clarification, Andrew. This is going to be a question for Marjory. If an employee refuses testing or refuses a vaccine once one becomes available, is that grounds for possible termination?
It certainly could be grounds, at least, for not allowing them in the workplace. And in terms of whether it could be grounds for termination, but boy, you could be inviting a lawsuit, especially in this day and age where there's a lot of debate about how effective the testing is, how reliable. I am sure there'll be similar debates about the vaccine. Nevertheless, I think that there will be processes that you will be able to develop that will allow the employee, allow you the liberty to be able to terminate somebody if your practice is that they have to do this to come in and you can show there's a legitimate business need and you're treating everybody the same. You may be able to do it, but it probably, you have to do a risk analysis as to, is it worth the lawsuit that may ensue if you do it? So I try to avoid in my practice, even if I can win a lawsuit, sometimes I give advice where we try to avoid the lawsuit.
Yeah, slippery slope. That's not an easy question. Another question here in from Lyndon. If someone from the same household has an employee who has heightened vulnerability to the virus, must we treat that employee as an individual with a disability for the purpose of ADA?
So I think I understand the question. It's where the employee themselves doesn't have the health condition, but somebody in their household has it. So the ADA is interesting. You can't discriminate against people who are associated with those who have a disability, but there's no affirmative obligation to accommodate somebody to take care of somebody who has a disability. So under the strict, narrow meaning of the ADA, I do not believe that that would apply, but you need to be very cautious because the EEOC is putting some pressure on employers to consider accommodations for high-risk individuals. I can't remember if the guidance refers to if they're in a household with a high-risk individual, but I know that the state and local orders, a lot of them are saying that you should give accommodations not just to your employees who are high risk, but also if they have a family member who is high risk.
Thanks, Marjory. And this question kind of operates in the reverse of that. If we have an employee with a commonly known underlying condition, we know the person has asthma, we know the person is pregnant, can we as an employer compel them to stay home, to not come into the office?
You're into very risky territory. My instinct is to say no. The EEOC and its guidance it's interesting the things they're willing to give on and the things they're not willing to give on, but they stressed you should not be making assumptions about what you think is safe for the person. If their own healthcare provider has advised them that it's safe and they're engaging in the proper social distancing requirements and other cleaning requirements that everybody else is doing, you are at serious risk if you make the decision for them that you're not going to allow them into the workplace. And I've seen this come up in so many ways. I mean, I think sometimes employers think they're doing things to be kind, and it can end up sort of backfiring on them because the employee needs to work, wants to work. Maybe the employer has a misunderstanding of how deep the risk is. So I think you're treading into dangerous territory.
Another question for Marjory here. If we're compelling employees to work from home, as an employer, are we required to pay for internet and other related expenses, cell phone usage, et cetera, that an employee may have that's related to working at home?
So that depends very much on state law requirements. California, for example, not surprisingly, has one of the most employee favorable laws in terms of being required to pay for business expenses. That is coming up in a lot of discussions, including even at Sun Life, we're having those discussions. I think you also need to bear in mind that there is going to be the potential for union activity. And so if employees feel that they're being treated unfairly, you may run the risk that they organize around this. So you have to balance a combination of what you're required to do along with managing employee relations issues. I do know, I follow a blog of employers, and a number of employers are starting to give employees a certain amount of money towards their internet. And the amounts vary in terms of what they're willing to do. So I think sometimes a small gesture to at least recognize the cost and help contribute towards it can go a long way with employees.
Thank you. Andrew, a question in from Mimi. If an employee lives in a household with an extended family, aunts, uncles, cousins, can claiming the need to care for any of these extended family members count for the Expanded Family Leave Act?
Well, in that case, guidance has already come out, and it says that caring for somebody is generally confined to only those who you can reasonably expect to need to care for. So, for example, a spouse, a minor child, or a relative with a disability. Aunts, uncles, cousins, and so forth are generally not covered by that. And while an individual could certainly try to make that case, that goes against the way that the guidance is currently showing.
Thank you. Thank you, Andrew. Marjory, If an employee refuses to wear PPP, facial mask, fails to maintain social distancing, can the employer legally impose the condition that the employees have to leave the workplace for the safety of others?
It depends. I'm like a typical lawyer. It depends on the particular facts. So some things to bear in mind: are they refusing because there's an underlying medical condition, some reason that they can't? Including, I've seen some cases say that people who have behavioral conditions may not be able to wear face masks, or potentially, I don't know, I could conceivably, maybe they can't control their impulses and maintain social distances. So you could get into this weird area of having to accommodate. Another thing I think you need to be really careful of is that you enforce that consistently. Because if you decide, I've done employment law long enough to know that when the workers who you like do things that are annoying, you don't react sometimes as strongly as the workers you don't like. And so you could be opening yourself up to a discrimination claim if you go out of your way to terminate one person who violated the social distancing guidelines, but they can point to 5 other people who did the same thing and you didn't terminate them. So the devil is in the details a lot of times. I would, before you terminate, I would make sure you give plenty of warnings and opportunities to improve, and that you hear why the employee is saying they can't do these things. But yes, I think ultimately, push come to shove, with proper legal advice, you could terminate the person.
Marjory, thank you. This is a question in from Caroline. Many of our employees are now in different locations across the country, sheltering in place. How long can they be at an alternate address before we need to update permanent addresses for taxes and workers' comp purposes?
Is that for me or for Andrew?
That's an Andrew question. We'll give you a break, Marjory.
Golly, that was a Marjory question. The answer is not going to be an easy one, because different states have different rules on their workers' comp, and it goes state by state by state. And unfortunately, you're going to have to look up each state where that might be. With taxes, we're expecting guidance out from the IRS with some specifics. But again, that will not help on the state by state by state level. As you can imagine, there are going to be some states that are more revenue hungry. I'm sure the runway will be much shorter with them. So the New Yorks and Californias, if you've been working at home for over an hour, then you're a permanent resident there. I think other states are going to be a lot more forgiving given the circumstances. So I wish I had an easy answer for you, but unfortunately, it's going to involve going to each state and finding out what their rules are and keeping up to date on what those are, because they're constantly changing.
So we're almost at the top of the hour. We get time for 1 or 2 more questions left here. This is in from Stephen. Marjory, you recommend that we have our employees sign a waiver of liability, just thinking in terms of workers' compensation and acknowledgement that everyone is entering the office, quote unquote, at their own risk.
So that is a great question. I'm really glad you asked it. That is also a hot topic that people are discussing. So there's a few legal problems with it. Most workers' comp laws, you can't waive your rights. So I don't believe it would be an effective legally binding waiver, but I have wondered whether an employer would be well advised to have a statement that people sign saying they acknowledge that COVID-19 is, an unknown and to a certain extent uncontrollable situation. It's a pandemic. Everybody's learning. They understand there are risks coming in, that if they see any safety concerns, they will report them immediately. I think there are things that could be good for people to sign that may help you later in terms of limiting liability. But I don't think an actual literal waiver is first of all, I think it's going to be frowned upon, and I don't think it would be effective. But I do think informed consent, that's what they call it in the medical world, where you sign something acknowledging that bad things can happen. It can help limit liability later.
Terrific, thank you. And I'm going to put the last question back here to Andrew. Andrew, can you please clarify how paid sick leave and the new FMLA regulations work together?
Okay, so the new FMLA regulations are specifically for if you have a youngster who is out of school. And, above and beyond that, the extended FMLA does not apply. The paid sick leave, right, if you or an individual that you need to care for is the reason you're taking paid sick leave, that can count as the first 2 weeks in that 12-week of extended FMLA if you have both conditions at the same time. You're taking care of someone and you have youngsters who are out of school, or you are ill and you have youngsters without daycare. For more specifics on any specific situation, please feel free to reach out and we can work through it with you.
One more question, and this is going to be for Marjory, and we'll end on a lighter note. Any advice on what we should do with the communal refrigerator?
Oh, that is not one that I have seen guidance given on, but I would say close it. I think, they're urging that kitchens be closed. So I think communal things in general are problematic.
Well, thank you so much to everybody who joined us today, and thank you to our panelists. We really appreciate everyone taking time out of their day, and we hope that everyone has a safe rest of the week and goes into the weekend in good spirits. Thank you all very much.